joining another one of Ashbur's webinars. My name is Amber Hines and I am the owner of Ashbur. We specialize in Medicaid compliant annuities, specifically short-term annuities for clients that are looking to spend down for Medicaid qualification purposes. Today, I'm very excited to have Attorney Marcus Foote with us of In Marriage QDRO. He's going to be talking about a powerful strategy that can be used in certain situations to transfer qualified assets from one spouse to another, as well as pensions and other income streams that can be beneficial to clients that are looking to qualify for Medicaid and do that in a very tax efficient way. We have a copy of Marcus's slides on the GoToWebinar dashboard if you're interested in a copy of those. And he will also allow for questions throughout the presentation today. If you have any of those, feel free to type those into the questions bar of the GoToWebinar dashboard as well. And with that, I'd like to hand everything over to you, Marcus, if you are ready to go.
Yes, I appreciate it. On the questions, I'm not sure because on this one, does the questions come up to me, or are you going to read those questions if they have and they type them into it?
Yes, so they'll type them into the questions bar and then I can read them to you as they come in.
Great. All right. So yes, as I told you, the presentation is kind of like 3 different parts. So we can, after each part, I'll ask for if there were any questions. Okay. All right. So again, I appreciate the opportunity to do this. As she said, the In Marriage QDRO it is something that we've been doing for several years now, and what it allows is it allows basically control of certain types of investments, and we'll go through a list of them in detail towards the end. But basically, it's company pensions and 401ks, 403bs, qualified plans. So it is a tool. It's not a financial plan. It's a tool that basically allows you to get access to funds that were not necessarily accessible. And that could be done for financial investments, estate planning, all kinds of different things. I'm aware the presentation we're doing today with Ashbur is dealing with Medicaid compliant annuities, so they'll probably have a certain audience. So some of the applications will be more relevant than others, but I'm trying to give an overall view of what this tool is used for. As I said, the current ways that you could actually get access to your retirement plan is you could retire. And so if you could do that, then you don't need our purposes. You can do other types of movements. You can quit, you can divorce, you can get plan loans. The issues with all these are when you're dealing with a situation where you may need a Medicaid client compliant annuity, or you're doing anything dealing with Medicare, it's not to get access to the funds. The issue of the In Marriage QDRO that these other access points cannot do is it can actually transfer the funds to your spouse that's staying at home, or to your client's spouse that's staying at home, without doing some kind of horrendous tax spin down and incurring tax problems. And that's what kind of the secret sauce of the In Marriage QDRO is. So for those that we're talking about, maybe in that you know what I'm talking about, for some people it may be Latin. So let me just describe what is a QDRO. Well, normally it's something that most people will hear about in the context of a divorce, right? Me and my wife got divorced. She would do a domestic relations order or a QDRO to get funds from my 401k, or I get it from her pension, or something to that effect. So it is an order that's actually signed by a state court judge, and it has to be approved by the judge and then sent to the plan administrator. So it is basically 99% just like a divorce QDRO, except it is dealing with 2 parties that are married. A divorce is not filed, the legal separation is not filed, nothing like that. So we go, well, why would that be allowed? And this on the screen is why. The definitions both in the tax code and in the ERISA code where the QDRO was created specifically has as the definition of alternate payee a spouse, comma, former spouse. Now, I know a lot of y'all see the word child or other dependent, and as good estate planning attorneys and other types of attorneys or financial people, your brain's going to start going, oh, well, we can do this for other types of estate planning mechanisms. I only deal with spouses. I've not been brave enough, or nor do I think it would be a good idea to try to start doing intergenerational transfers of retirement plans in this manner. So I'm only dealing with current spouses, but as you can see, the definition clearly allows for that. Additionally, for people that may or may not know, in the ERISA section, Title 29, that deals with QDROs, the words divorce or legal separation do not appear. I had been doing QDROs because by nature, by profession, I'm a family law, board certified family law attorney in Louisiana. And I've been doing QDROs probably for 10 to 15 years before I came up with the InMarriage QDRO process. And it was just, everybody said, oh, that's what you only do is for divorces. But it was a coincidence that I found that those words don't actually appear in the statute. And not only do they not appear in the statute, in the other section of the US Code that deals with IRA regulations, it actually has the words incident to a divorce. So for those attorneys in the audience, if you're doing a legal construction and you have two statutes, both of them dealing with similar situations, one requires a divorce and the other one, the word divorce does not actually appear in the entire statute, you can draw your conclusions as to whether it's a predicate. Not only that, you have the Department of Labor, which is the company and agency that governs ERISA, and they actually have this specific question in their materials on their website. And I give the website citation on the bottom, you can go read it. And it asks, must it be issued as part of the divorce proceeding? And the answer is no. So again, you have to create a marital right. You can't have a sham transaction, and we're going to talk about that in a second. But the issue of whether there is a divorce requirement, the short answer is there's not. So let me give you an example. I always take Louisiana. I have another one for another state, but I always do Louisiana since it's where I kind of originated this from. And this is an article 2336 that's in the Louisiana Civil Code, and you can see the highlighted part. It says during the existence of the community property regime, the spouses may come up with a voluntary partition. So again, if me and my wife wanted to do an in-marriage QDRO, and let's say I had a 401k that had $200,000 in it, I could easily say, all right, well, I get 100,000 and my wife gets 100,000. That's what we would do if we got a divorce. So we can do the same thing now and do a partial property settlement just with that while we're married without a petition for divorce. If she is then getting $100,000, the QDRO, we would do a $100,000 QDRO that would be transferred into her name as the executing portion of for that new right, that property right that she was acquired. If we wanted to get access to the entire $200,000, we can bring in another asset and say, all right, well, I'll keep a pension and she gets the whole 200,000, and we do a partial property settlement on two assets. You can also do a straight donation in Louisiana to her if I wanted to give her all of the funds. So again, this is the donation in Louisiana, and it's in the family code, it's in the domestic relations statute. So there's 2 or 3 different ways of spousal transactions where I can acquire or my wife could acquire a spousal or a property interest, which is what triggers the federal QDRO statute. Here's an example for North Carolina, which is a non-community property state. Louisiana is a community property state. North Carolina is a non-community property state. They just don't call them donations, they call them quit claims. They're quit claim contracts between spouses. And it is in a section that does not deal with divorce. So again, you can read it, and if Amber provides all the rest of the slide deck at your own leisure, you can go and Google it and research it. But it says that you can quit claim search right, just like if she wanted to give in North Carolina an acre of property to my wife, or parts of cash, or a car. Same thing with a 401k or a pension. Last one is in California. They call it transmutation. So even though this thing differs per state, it all surrounds kind of a spousal agreement or a interspousal contract that actually creates a property interest, and that's what triggers the QDRO. So Amber, next we're going to get into the why would you do it and the applications and some of the some of the particulars and applications and practicalities. But I'll stop now. Were there any questions thus far?
I don't see any typed in right now.
All right. And again, just interrupt me if anybody wants to ask a question on the legality of it. I try to do it kind of fast because most people are interested in what can this do for it and why would I ever use it, and not necessarily all of the history of the legalities. But I want them, if it's a new process, I wanted everybody to be comfortable with the legality of it before they even started looking into it. So let me look at the first one. There is the ability to actually, if for those that know a 401k, you'll think, and you've been taught for 30 years, if a person liquidates something from a 401k, they're going to pay a 10% early withdrawal penalty. But let me introduce you to page 35 of the IRS publication 757, and it says the 10% additional tax does not apply to distributions taken, and I give you some of the other explanations. There's about 10 of them, exemptions, but the bold one says from a qualified qualified retirement plan to an alternate payee under a QDRO. Now, divorce attorneys have been utilizing this statute for, well, since 1984 when this definition came up. And it does not, now you still pay the taxes on it, but on that example that I gave of 100,000, my wife could liquidate 80,000 of that, or 100,000 of it. The government would withhold 20% as a withholding, and there's no 10% penalty, and then whatever our tax rate is following year, we'd either owe some more, or we might get back some of that if we had some good tax planning. So again, you do not pay the 10%. So some people may just want to use the In Marriage QDRO to get access to the funds, literally to spend it down without paying the 10% penalty. I go on here, it's better than an in-service distribution or a loan or things of that sort. Again, when you're doing Medicaid planning, you're not really going to want to do any of these in-service distributions anyway. But even if you could, to try to spin down, doing it through the In Marriage QDRO is probably going to be a more tax-efficient way of doing it. Now, the one thing that I think would apply to several of the people in the audience today is this, and this is an exact case that we did probably 6 or 7 years ago. With an attorney in Louisiana. Obviously, I changed the names, but let's just say Mr. Smith's wife had dementia. She was in good condition, but she was going into a care facility. She had a pension of probably about $1,936 a month, a little under $2,000. And this is basically what their primary income was. In most situations, again, I'm not an estate planning attorney, so I'm sure some of y'all will correct me if I say anything wrong, but in most situations, that $1,936 is going to go to the nursing home if you want to get a partial qualification for Medicaid or for Medicare. And the goal is, can we wave some kind of magic wand to where the husband gets to keep that $1,936? And the short answer is yes. Doing an in-marriage QDRO, if your state allows what most people call the name on the check rule, which Louisiana does, that wife was able to transfer to the husband through a donation the entire 100% of her pension. At that point, the pension is now written to his name, and he gets to keep it at wherever he's living. So that couple is going to be basically saving $23,000 just in income because we were able to basically get it into his name. Now, if she were to die, if he were to die, QDROs are basically permanent garnishments. So if he were to die, that benefit is going to go back to her because there's no longer a garnishment. So you got to be aware of that. But as long as both of them live, that couple's going to be saving roughly $24,000 a year. Some people might think, well, but she was having dementia. How could she sign? Well, that becomes the estate planning attorney's issue. Hopefully, and in this case there was a very comprehensive power of attorney when she still had capacity that allowed the husband to do self-dealing. So in this particular situation, they were able to get this done through the power of attorney. Again, that would depend upon the state, that would depend upon the documentation before we got involved. I'm just telling you what's possible, not that it would work in every situation. Now, you could do other types of things. For some of the people that may not be applying to deal with Medicaid or spin downs, you can do this just to get access to diversify investments. If you don't like what you think is going to happen in the economy, and let's say George was still 3 to 5 years away from retirement, he might want to roll it over into his wife's IRA, go to their financial advisor or estate planning attorney and start doing tax planning in advance of his retirement because he couldn't get access to the funds prior to that. So again, if you like your 401k, you can keep your 401k. You don't have to do this. But if you had a client that really wanted to do some tax planning, wanted to do some, and we'll talk about in a second, say some Roth IRA conversions, but they can't get access to the funds, the In-Marriage QDRO allows that pathway to get access to the funds. It allows to pensions. Let's say you don't have a 401k, you've already converted that to an IRA or you never had it, but you have a pension. Again, you can actually, not every, but some companies allow lump sum QDROs, meaning you can liquidate part of your pension to your wife's IRA to start doing tax planning, Roth conversions, other things. We did one about 3 years ago for an Exxon employee where he did this and he took over $1 million out of his pension. And then the next year when the interest rates went up, for those that are number geeks and nerds, y'all know what I'm about to say. When interest rates go up, the present value of your pension for private companies go down. So he saved tens of thousands of dollars just in the fact that he was able to get the funds out before the interest rates changed the present value of his pension. For estate planning attorneys, you have clients, you can also delay minimum distributions. I'm sure some of y'all will have clients that might be 70 years old, married to someone that's 60 years old. And they're going to be being required to do minimum distributions in 2 years. They can actually roll a significant amount of funds down to their spouse and delay the RMDs for 10 years. Again, if you can do it, maybe it's worth it, maybe it's not worth it, it's just an option. In the same scenario, the one that I just gave was again another actual scenario that we had, and there was two parts to the benefit. Not only was he delaying the RMDs, this was his second marriage, and he had been married to his second wife after his first wife died 20 years. So, you know, it's not like he just married this person 3 years ago. They've been married for several years, but he wanted to leave a lot of his estate to the 3 children of the first marriage. And so he didn't want them to have any fights. So what he did was he literally took $600,000 of his 401k and rolled it to his current wife through the In Marriage QDRO. She rolls it into her IRA in her name, and now it's not part of his estate. And now he can leave the rest of his estate to his 3 children without any fights between the spouses. Now, who's the happiest of all of this scenario? I would think it's the wife's IRA, the wife's financial advisor, because now he or she has an IRA with $600,000 that they are managing that they were not have access to 6 months before. Other uses, again, I've had clients that rolled it into an IRA. We did one in Arkansas. We rolled it into a UPS FedEx pilot, rolled it into his wife's self-directed IRA, and they bought a restaurant with it. You can do all kinds of things. Again, it's not a financial tool, and I don't know whether that restaurant did good or didn't do good. That's my role, is to get is a tool to get access to funds and to be able to legally move these funds around. This is a chart that's on our website that will show different scenarios of what the In Marriage QDRO can do. Again, if Amber's sending y'all the slide deck, y'all can see that. These are really small print, so I'm not going to go over it right now. But it is in the package that for the PowerPoint presentation. Lastly, these are the plans that are eligible. 401ks, 403bs. We've done them for the Federal Thrift Savings Plan before, Deferred Compensation 457 plans. You cannot do them for the military or federal pensions, state pensions, things of that sort. You can also not do a direct IRA to IRA transfer, but I say there's a workaround. Well, there's 2 ways to do that. If you have a client that has a huge, say $400,000 IRA and a $30,000 401k, what can occur, and you can look this up on your own, IRS allows people to transfer funds from their IRA to their 401k. So although I'm not involved in that step, the person could actually transfer, if they wanted to get it to their spouse's name, money from the IRA to the 401k, then do an In Marriage QDRO to the other spouse. And then you could either liquidate it or just have it on a different name on the check for purposes of Medicaid. Again, it just allows for flexibility. The risks, there are 3. Death, which you can minimize by beneficiary designations and making sure the estate planning is done correctly. So it's a risk. I don't think it's a big risk. The big risk and the sole risk is divorce, right? These are not sham transactions. If in the example I gave at the beginning, if me and my wife both got $100,000 out of a 401k, we're both getting the same thing. So even if she were to divorce me in the future, I'm not really losing a whole bunch. If I gifted her or donated the whole $200 to her and she left, depending upon the state, I don't get any of that in the divorce. Now, there are some non-community property states that would allow you to even divide that, even her new IRA is part of the marital estate. I'm sure there's 50 states, there's gonna be 50 different answers on the level of risk that would pose in an eventual divorce. You just need to know it is a risk. And the last one is the cost. The cost can be minimized to some extent, because I will tell you, we've had success in about 30 states. The other ones, we just haven't tried. I'll show you a map in a second. There's only 3 or 4 states that we have not found any success, and that's another podcast or another webinar I can go into. We're running about a 92% success rate, and we give nearly a full refund for the ones that do not work. We do not want any referral to pay money and be out the money, and then it's just not work. So we give a nearly fully refund for that scenario. Here is an example of all the states. The ones that are green are the ones that we've done them and gotten approved. It is missing one. Oregon should be green. I didn't get it changed by our website guide before this webinar. So Oregon is yellow, but it should be green. We are currently doing one in Hawaii, so we'll hopefully see whether that will be green in the future. And the only ones that we've been turned down on is Iowa and Colorado. So those, if you're from those 2, you're probably out of luck. But for everything else, I'm willing to try on any of the ones that are yellow, because until you try, you're never going to know. So again, that's kind of it. Amber, I'll stop talking and let anybody answer any questions that they may have.
Awesome, thank you. The only question that we did have was what happens with this strategy if there's a divorce after, which you've answered that question here. So can you talk a little bit about what your process looks like if we do have attendees that are on today's session and they want to learn more about working with you, or if they have a potential case that they think would be suitable for this type of strategy?
Yes, so the phone number at the bottom of this screen is to my assistant named Jennifer. So you can always, if you have some general questions, you can call Jennifer at any time. On our website, we have a Calendly program that schedules 15-minute phone or Zoom conferences with me if y'all have any very specific things that Jennifer cannot answer. And so it has my calendar on there. It is as simple as either calling Jennifer on this number or looking on our website, which is InMarriageQDRO.com, and just picking a 15-minute phone or Zoom to discuss possible cases. We do those free of charge, and depending upon which state you're in and or the client, not you, but the client is in, and what type of plan, we would go over the costs and everything there. But again, it is for certain people, it is something that they could not otherwise get access to in their planning.
Awesome. We do have a question here from a Massachusetts attorney. It says long-term marriage divorce would usually require a 50-50 split. Can the In Marriage QDRO process result in a more favorable split of the assets to the well spouse?
Well, you could try to split it up as much as you want in a divorce. A lot of people, when they're doing these In Marriage QDROs, don't want to get, their houses involved or their businesses or other stuff like that. So they want to kind of stick it just and keep it just to transactions involving the retirement plans. But the answer would be probably so. Again, we've done them in Massachusetts. A couple of times. I believe most of those did not involve more than just the retirement plan. So how equitable it is, I mean, you can split it up as in whatever way you wanted to split it up. But again, I haven't dealt with non-retirement plans in a divorce settlement like that.
Okay. Can you talk a little bit about how long this process takes? This is coming from a North Carolina attorney.
All right, so we tell everybody, we actually have stats, but I'm not going to bore y'all with that. But we tell everybody 3 months, right at 100 days. I would think I did one, I would say probably the fastest we can get it done is probably going to be in the 70-day range. And the reason why is, A, you got to meet the client, make sure it's correct. Do the prep work for the type of plan that they have, then make sure that all the documents, we get an attorney in that state, because I'm not licensed in all these states. So we have network of attorneys that work with us. Once it's prepared, then it has to be signed by the client. Then it has to be submitted to the court. Sometimes the court will sign it immediately. So you could probably get it done in 70 days if the judge signs it fairly soon. Some judges require a hearing where they're going to want to make sure nobody's being taken advantage of. So that might be 30 days later, which means we're just twiddling our thumbs until the hearing date for the judge to sign it. Once the judge signs it, we have to send it to the plan administrator, and some of those will get qualified within 2 or so weeks. Some of them take 45 days. So again, there's a couple of gatekeepers here that would control the timing. So I tell everybody right at 100 days. Some of them I can get done sooner. Some of them will take 120 days to get done. And if you're in California, it's going to be probably 6 months.
Okay, there's a couple more questions here. If you only have IRAs, can you create a 401k through an LLC so that you can do the In Marriage QDRO?
Yes, I didn't go over that because that's really becomes very nuanced. But the answer is yes, and I've seen that done. I'm not a corporate attorney, so I don't get involved in the creation of the LLCs. But I have seen people do that, roll over the IRA into a solo or a uni 401k, and then at that point it is governed by ERISA, and we've been able to do an In Marriage QDRO. So yes. Okay.
Can you provide a range of your fees for services?
Yeah. So the range is usually starting between 6,500 to 8,000, depending upon the state. I would say a vast majority of the states are going to be right at 7,000, except Louisiana, obviously, because I do those myself, so I don't have to hire another attorney. And so those fees, let's just say it's 7,000. That covers everything. It covers the court costs. It includes the attorney, includes our fees, includes everything. And again, if it works, great. It usually is worth the 7,000. If it doesn't work for any reason, the judge doesn't sign it, the plan doesn't approve it, any reason, we refund everything but $500 plus the court costs. So the client's literally only risking, $750 is what they're physically risking. So that's kind of the way we try to keep it as simple as possible. If you're doing multiples, so you're doing 2 of them, we don't charge 7,000 twice. We charge 7,000 for the first one, and I think 1,250 for the second one. So it's going to be in that range if you're trying to do multiple ones.
Okay. We have a question here about, you said something about funds in a retirement account transferred to the spouse would return to the transferring spouse upon the death of the transferee. Can you talk more about this?
Yeah. So if that's for a pension. So that's not talking about a 401k. So that screen was only about a pension. If you can actually do a QDRO before the pension is commenced, then you can actually split the pension into 2, and that would not be applicable. Most people that are going to be doing these types of pension transfers have already commenced the benefit. They're probably older, one of them going to the nursing home. So the benefit has already been in pay status. Under that scenario, a QDRO doesn't split the pension like it splits a 401k. It actually acts as a permanent garnishment. And if the at-home spouse, the alternate pay, the non-member spouse dies, then that garnishment stops, which means now the person that went into the nursing home or the facility, the original participant, basically gets all of their pension back because the QDRO stopped.
Okay, we have a question here pertaining to Virginia. It says, what is the initial pleading document used to begin the process without a divorce petition?
Depending on the type of transaction you do, we call it a couple of different things, but it's basically like a petition to enforce an interspousal agreement, whether it's a gift, whether it's a donation, whether it's a postnuptial agreement. There's a couple of different ways we would call it, but it's going to be called something similar to that.
Okay. I think we covered all of the questions, at least that have been typed in at this point. But again, obviously your contact information is on the screen if anybody has any questions afterwards. I appreciate your time, Marcus. Thank you for a great presentation. I hope everybody found this informative, and thank you for joining us today.
Thank you, Amber.
Take care.